Basically, I think going to be a continuation of Dr. Ron Watermeyer's keynote address that he gave yesterday. And then after that, we're going to have our session 3 started. And session 3 is going to be on contractors' claims.
I've been asked to talk today on addressing changing the plan post-contract award. And I think what this does is really tries to breach some of the issues that we spoke about yesterday around time and cost, and some of the issues that we will talk about today. And what I will do is I'll continue the story of the 2 projects that I had yesterday to illustrate the 2 extremes that we can see how things come about. So I think the thing is we've got to understand, and I think it came across very well yesterday, that risk is integral to infrastructure. Whoever is risk averse should never get involved in infrastructure because there's always going to be uncertainty, particularly at the start of a contract. Now, the changes in the scope of work of a contract are required to enhance quality, performance, or to address shortcomings which can impair performance, and it occurs very frequently. I don't believe that we will ever have situations where there's no change. Let me give you a quick example. You can build your own house, your dream house. You can engage an architect. You can look at all the drawings. You can even give you all the 3D models. But I bet you what happens is when the walls go up and the windows get put in and the doors go in, your spouse comes to you and says, "Dear, if we just move that door a little bit over this way or that window over this way, we can use this space and apply something different." True. It's going to happen. So what this address will highlight the desirable features of a contract and outline some drafting techniques to enable changes to be readily effected should the need arise. We ended up yesterday is looking that we had to manage the whole process through an underlying context, through delivery constraints, and through product controls. And we all agreed yesterday that the critical areas, cost and time, that were the issues that were the things that most impacted upon us. We had some aspects of quality as well, but it's usually all interrelated when things go out of control.
Before I start with mine, there's just a couple of things that I actually want to just echo what has said. You know, when we were faced with a major project in South Africa some 10 years ago, one of the questions that we asked ourselves was, how do we get local content maximized? How do we maximize local participation? How do we secure it? How do we go about tendering in that environment, still being fair, but at the same time getting what we need and getting what we want as our objectives? And it would have been very easy to add in a clause like you saw there, which is the MDB harmonized edition clause, which simply says we encourage. Quite frankly, that's a cop-out. That's saying we actually cannot get to a point where we really know what we want to do and we have to put something in. The problem with that approach is that by the time you get 6 months or 12 months or 24 months into a contract, you forget what the original intent was. You forget what the original problems were. And you start thinking, no, there's an obligation to perform.
So starting off then with how claims arise, how does a contractor become entitled to make claims? Well, as I said yesterday, in the context of time, claims may arise either under the contract or at law for breach of contract. Now, the contract will often prescribe the grounds and procedural requirements which the contractor has to follow. We've seen under FIDIC that clause 20.1 is the starting point. Whenever a contractor considers itself entitled to a claim, it must give a notice in accordance with clause 20.1. But it's important to remember that there are other requirements for notices dotted elsewhere throughout that particular form of contract, and the same is true, albeit to a lesser extent, in other forms of contract. So it's important to give the notice both under 20.1 and any other notice. So, for example, if the delay or cost is going to arise as a result of the discovery of fossils, then you'd need to give a notice both under the claims subclause 20.1 and also the specific subclause, clause 4.24.
So as Mr. Letcher said, I'm going to give a brief overview of public-private partnerships, also known as PPPs. Now, there is not one single definition of a PPP, neither a legal definition of a PPP. But World Bank defines it as a long-term contract between a private party and a government entity for providing a public asset or service in which the private party bears significant risk and management responsibility, and remuneration is linked to performance.
Now, we have two main forms of financing: the corporate finance and also the project finance when it comes to infrastructure financing. The corporate finance structure is based mainly on the balance sheet of the company that is issuing the debt. The bigger your balance sheet, the more business you're able to do, the more you're able to borrow. Now, because of the pressures on business and the fact that balance sheet may not be big enough to secure or implement large projects, there has to be another way. Another way has been found over the past 60 years where project finance structures have been used to finance large-scale infrastructure projects. Now, what is the basic tenet of project finance? As you have said, in the case of corporate finance, you have to leverage your balance sheet. The more assets you have, the more money you have, the more you are able to operate.